The NCAA is up against the clock. On July 1st, name, image, and likeness bills in 6 states, Texas, New Mexico, Mississippi, Alabama, Florida, and Georgia, will go into effect. In those states, student athletes will be allowed to earn compensation from endorsement deals, business ventures, and public appearances, and the NCAA is running out of time to respond at the organizational level. After a recent scathing Supreme Court case and a new proposal from 6 conference commissioners, we take a look at what to expect come the 1st of July. What's the NCAA's new plan for NIL? How would that work? Traditions alone cannot justify the NCAA's decision to build a massive money-raising enterprise on the backs of student athletes who are not fairly compensated. The NCAA is not above the law. That is Supreme Court Justice Brett Kavanaugh delivering an opinion in NCAA versus Alston. In a unanimous decision, the High Court rules that the NCAA cannot limit educational-related costs for student athletes. It opens the door for schools to offer extra benefits tied to academics. And with Kavanaugh's harsh words, the NCAA is put in a tough spot. The organization was scheduled to produce its own plans for NIL last January, but ultimately tabled any new guidance. Does the language in the Supreme Court case make the NCAA hesitant to put any guardrails on outside compensation? It's the question commissioners from 6 conferences are asking. These conference leaders are offering an 11th hour solution as the July 1st deadline looms. In a memo to the NCAA, they are asking to scrap any current NIL proposal the organization planned to adopt. In its place, this proposal would exempt the NCAA from NIL entirely. Schools in states with NIL laws will be permitted to follow them without penalty, while schools in states without NIL laws will be allowed to create and administer their own policies. It takes the onus off the NCAA and onto individual schools when it comes to administering NIL rules. They can create their own rules so long as NIL ventures aren't designed as pay-for-play or recruiting gifts. 15 additional states have name, image, and likeness laws that will kick in after July 1st, so time is of the essence. Is this temporary NIL solution the answer, or is the NCAA just punting until federal legislation can be drafted? More courtroom challenges could be coming in the age of NIL, but as for this proposal, that's how it would work.